Welcome to 189th episode of AAA Weekly Webinar Series. In the last two webinars, in our two videos, we have discussed petitions under Section 7 and under Section 9, how those petitions can be accepted by adjudicating authority and in what circumstances the petitions can be rejected by the adjudicating authority. Today is the most important one, that is the petition under Section 10, which is to be filed by the corporate person, the corporate debtor. So we are going to discuss today the application or petition under Section 10. In fact, this is the most difficult application. The requirement of various documents, updated documents, and also the reasons why all these applications can be rejected. In case we see the statistics, which are as per the IBBI newsletter for quarter ended June 2025, only 6% of the total applications are under Section 10. Only 6%. And in case the total applications filed before adjudicating authority under Section 7, 9 and 10 are 8,400. Out of that, the petitions under Section 10 are only 500. So these are the numbers which shows that the corporate debtors are adopting different routes when they understand that the company is under stress. Rather than resorting to Section 10, they are in fact doing applications, getting the applications filed from somebody else under Section 7 or under Section 9 only because the little lesser success. In fact, too less a success rate, too many rejections under Section 10. So Ankit, would you like to say something like primary, what are the reasons for such a huge rejection of petitions under Section 10?
So when we see this, we of course, when we look at the IBBI newsletter and look at how many cases have been admitted in CARP and how many have been admitted because of an application by a financial creditor, how many are admitted due to an application of an OC, and how many because of the CD themselves. As you said, there are only about 522 CRPs that have been initiated till date out of a total of 8,487 where the application has been filed by the corporate debtor themselves. This is a sharp contrast from the world view. In the US and in the Western countries, we see that more and more of these CRPs or insolvencies are actually filed by the company themselves. And as you said, rightly said, that operational creditors application is preferred because of lesser information requirement, lesser risk of fraudulent transactions coming on the surface because of the cooperation of the CD, and of course the requirement to submit various documents as we will be discussing forthwith in a Section 10 application as compared to a Section 9 or a Section 7 application.
So let us understand first of all the definition of corporate applicant, which is provided in Section 5, subsection 5 of IBC. The definition of corporate applicant is strangely very independent. First of all, the corporate debtor itself can be a corporate applicant. Then the second option is that the member or partner. Member means any shareholder, partner only in the case of limited liability partnerships, member or partner of the corporate debtor who is authorized to make an application for the CIRP under the constitutional document of the corporate debtor. Now, these are the two things are very important. One, that the member or partner must be authorized to file an insolvency application. Secondly, also under the constitutional document of the corporate debtor. So we have found various judicial pronouncements that if the member, means the shareholder, or a director is not authorized by 3/4 majority of the shareholders, and also that authority is also matching with the constitutional documents of the corporate debtor, may it be articles of association, may it be the limited liability partnership agreement. So that authority has to be there. So we'll come back on this particular matter. But then the third person, individual, who is in charge of managing the operations and resources of the corporate debtor. That means the managing director or a whole-time director who actually is responsible for overall management of the affairs of the company. Fourth, a person who has the control and supervision over the financial affairs of the corporate debtor. That means financial affairs, may it be director of finance, may be a CFO, even an employee CFO, even an employee managing director. They also have the eligibility to file an application under section 10, provided they are defined in the as key managerial personnel and the appropriate compliance of ROC filing has actually been done. So they are declared, they are announced as managing director, they are announced as the CFO of the company. So that actually is possible. So we have also found a judgment where the director who is filing a petition under section 10, he actually has been disqualified under section 164 of the Companies Act. The NCLT, the adjudicating authority, has held that a disqualified director cannot be authorized to file section 10 petitions. Coming to the point, when a company can apply for insolvency, first of all, there has to be a debt and there has to be a default. These two conditions are common with section 7 as well as section 9, and that has actually been held also by the Supreme Court in the first case, Innovative, that actually has held. And also, there is a threshold limit of 1 crore. Debt of 1 crore, outstanding debt of 1 crore, and there should be a default of that similar amount or more amount. That is the minimum requirement of the eligibility for filing section 10 application. So the most important reason why section 10 applications are not preferred by corporate debtors, corporate applicants, that reason is the very detailed requirement of information and documents. I will actually try to tell you what all documents are required for filing a petition under section 10. Number one, the company's books of accounts and other financial documents for a specified period to prove the debt and amount in default. In fact, I'll come in detail what is the company's books of accounts and financial documents. Secondly, details of the proposed resolution professional, but that has actually been in the proposed amendment bill 2025. This requirement has been dispensed with. Now, this authority would not be within the hands of the corporate debtor, like who would be their RP. Once an application is made under section 10, the IRP would be appointed by NCLT after taking the name from IBBI, that means from panel. Then a special resolution passed by the shareholders of the company or a resolution passed by at least 3/4, 75% of the total number of partners of the corporate debtor approving filing of the application. So first of all, a special resolution in case it is a company, and in case it is a limited liability partnership, then 75% of the total number of partners, they actually should be approving filing of an application. If no decision has been taken by the shareholders in an extraordinary general meeting, because the special resolution can be passed only in annual general meeting or in extraordinary general meeting, and a director filed the application on the basis of a board of directors resolution, that is not valid. This has been held by NCLT in the case of Gaza Trustee Company Private Limited versus Haldia Coke and Chemicals Private Limited. Most of these cases are very old cases, 2017, 2018, because when this section 29A was inserted, that was inserted in November 2017. And before that, most of these applications were filed, and most of these cases, in fact, in 2017-18, more than 100 applications were filed. So instead of out of these 500 applications that we are saying, more than 20% applications were filed in 1 year, and that was before the insertion of Section 29A. So this is, but then after that, this number started declining a lot. Simply board of directors are not authorized. Simply board of directors are not authorized to file a petition under Section 10. It has to be approved by, so first of all, there has to be a approval by way of a special resolution from shareholders. Then there has to be a board approval for the person who is signing all the applications. And in the case of limited liability partnership, it is required 75% of the partners. So this is what is the basic requirement. And also, first of all, there has to be a debt and there has to be a default. And in the case of a default of an operational debt, in the case of a default of an operational debt, then we actually need to enclose along with the petition copy of the invoice, demand notice served by the operational creditor on the CD, record of default obtained through the information utility, any other document, and written communication. So the relevant books of account, when we say the detailed information required by the code as far as the regulation would be as under. 1. Audited financial statements of the corporate debtor for the last 2 financial years and the provisional financial statements for the current financial year made up to a date, not earlier than 14 days from the date of application. So in case I am making an application today, that means that I should have the provisional balance sheet as on say 19th or maybe 14 days back. So that is what is the difficulty. It is very difficult to prepare all these statements, and then is the statement of affair again prepared up to a date not less than 14 days from the date of application, and it must include assets and liabilities. Secured property details means all those properties which are mortgaged to the creditors. Credit information, connected party debts, guarantees issued or guarantees taken, members and partners shareholding, and then the authority documents for filing Section 10 application, that is extract from the constitutional documents like Article of Association, Limited Liability Partnership Agreement, Partnership Deed, or Shareholders Agreement, that is required to be attached. And it must explicitly record the applicant's authority to move insolvency proceedings. If the application is an individual managing operations, financial affairs, suppose that application is being filed by the managing director or CFO of the company, then what is required is the one employment agreement, the constitutional document, ROC filing, board resolutions like MGT 7, DIR 12, all these documents are supposed to be attached along with the petition. Now, these filings should also confirm that this managing director or this CFO has a complete control on the business of the company, operations of the company, or the finances of the company. That also has to be reflected. Application is to be filed in Form 6 and as per Rule 7 of the Insolvency and Bankruptcy Application to Adjudicating Authority rules. And then the role of the adjudicating authority. The adjudicating authority will admit the application if it is complete in all respects. It can reject the application if it is not complete, and then the opportunity to rectify can be given. Now, the Supreme Court, in fact, has also held in one case. Of course, after that, I don't think that is really important, because in the amendment bill, the NCLT has again been kind of under obligation to provide at least 7 days window to correct any kind of error in the application. Now, the first part is to understand the debt and the default. That is the first part which the adjudicating authority will see. So in this case, the NCL80, in one case, that is Unigreen Global Private Limited versus Punjab National Bank, NCL80 in fact, and she has said that under both section 7 and 10, the two factors are common. The debt is due and there is a default. Subsection 4 of section 7 is similar to that of subsection 4 of section 10. Therefore, NCL 80 held that the law laid down by Honorable Supreme Court in Innovative Industries Limited versus ICICI Bank is applicable for section 10 also, wherein the Honorable Supreme Court observed as the moment the adjudicating authority is satisfied that a default has occurred, the application must be admitted unless it is incomplete, in which case it may give notice to the applicant to rectify the defects within 7 days from the receipt of a notice from the adjudicating authority. And also, in some of the cases, the NCL 80 has in fact rejected the application because the company is making profit, company is doing good business, and NCL 80 says, and that is in the case of Vumit Shared Stocks and Investments Private Limited versus Securities and Exchange Board of India, NCLT has held that where an applicant is generating sufficient income and profit, the application filed under section 10 may be rejected on such grounds. So, Ankit, I think you need to see up till what you would like to add here in this so far.
So one important aspect which is required to be shared here is that Section 10 applications have this reputation of being applications which are frequently fraudulent in nature, and one of the reasons why that is understood by the benches and understood by the public is that when these companies come to NCLT under CARP, many understand that at that stage there is little left in these companies to be revived under insolvency, and normally it is seen that they are only coming to NCLT to protect themselves from the creditors and waive their debts as part of the process. To kind of look into this, what we did was we compared the number of cases which have gone into liquidation. So we saw that as compared to a total of about 7% cases that are there in the country where initiation was done by corporate debtors, about 12% of the total liquidation of those cases which have gone into liquidation are those cases which were initiated by the CD. So the number of cases which have gone to liquidation are almost double, whereas total number of cases are 7% of the total cases. Cases which have gone into liquidation are way more. Secondly, what is important here is to state how a few recent judgments in 2024 and 2025 have talked about the interlinkage between initiation of a section, filing and initiation of a section 10 application vis-a-vis recovery or SARFAESI proceedings against the company. So we have in 2024 an NCLAT judgment where the NCLAT judgment said that an section 10 application was fraudulent and malicious in nature because it seemed to them that the company is solvent, the company can pay the debts, but the company is not willing to pay its debts, and the company is coming to Section 10 only to protect itself from the recovery proceedings initiated by a bank. And we also have a recent case which is called Gets Tables Private Limited, where State Bank of India was the respondent and the company became the appellant in NCLAT, where it was held that pending SARFAESI proceedings in isolation cannot be reason to label a Section 10 application as a fraudulent application. So, for those companies where they can establish that their entity is insolvent, that they don't have the means to finance to take care of debt of more than 1 crore rupees, Section 10 application is still a viable option. And we also have provisions within 29A to allow the company and its promoters to take back the company in case the period of NPA and many other conditions therein are taken care of.
See why there are so many rejections of petition under Section 10. Because there is a general perception in the minds of creditors, and also the creditors keep on feeding that into the minds of adjudicating authority. So the first perception, and we in fact have analyzed various judgments from NCLT and NCLAT where these petitions have been rejected. We analyzed various reasons, and we actually now can present before you all those reasons which are presently being perceived by the creditors and by the adjudicating authority. And first and foremost is that most of these applications are being filed to seek protection against the creditors. Now, the protection to seek protection against the creditors' action can be like creditors are trying to initiate SARFAESI actions, so the corporate debtor will go for the Section 10 application. And also, in case the company's assets are being seized by any other department, that also immediately it will be option from the corporate debtor to go for insolvency, and then only to get some kind of temporary breathing so that the company can actually settle some of the issues. Also, the companies are going for insolvency under Section 10 only to get a revival, and but then most of these cases, the creditors are arguing before adjudicating authority that there are some criminal activities which are criminal actions are being taken by the investigating authorities. Therefore, the company has opted for this kind of application under Section 10. Now, the various grounds of dismissal of Section 10 applications that we have seen, that is the incomplete and unauthorized application. This is one. Two, debtor ineligible under Section 11. 3, fraudulent or malicious intent, abuse of process. 4, misuse to evade specific liability. 5, pending investigations or regulatory actions. 6, pendency of recovery proceedings, not sufficient in itself because the NCLT has held in many cases. Profit making or solvent entity. Then change of name and status of the corporate debtor while the application is pending. So these are various reasons why the applications have been rejected. Incomplete or unauthorized application. This has been held in the case of Pondicherry Extraction Industries Private Limited versus Bank of Baroda, a judgment dated 20th of January 2021, where the NCLT rejected the Section 10 application on the ground that the corporate applicant is surrounded by doubts and the balance sheet produced contains discrepancies. NCLT in fact reversed this order, set aside this order, and Section 10 was in fact initiated, and held that the moment NCLT is satisfied that there is a debt and there is a default, the application must be admitted unless it is incomplete. Now, NCLT is not supposed to look into detail about the accuracy of the financial statements. That is something which the NCLT is not supposed to look into that.
So in Gaja Trustee Company Private Limited versus Haldia Coke and Chemicals Private Limited, which is an NCLAT matter, the decision given on 19 July 2018 was that the debtor who had filed the application under Section 10 with merely a board resolution was not sufficient, and it was held that the shareholder special resolution is mandatory. If the debtor has not provided all required information, books of accounts, list of creditors, etc., the application is incomplete and liable for rejection, subject to 7-day cure period. So this is what was held in 2018, and we understand that there are other judgments also since then which have very clearly said that shareholder special resolution is required for a Section 10 application. It cannot move forward with a board resolution. In Krishna Craftex Private Limited versus HDFC Bank, again the NCLAT decided in January 2018. It was held by NCLAT that non-disclosure of facts unrelated to Section 10 and Form 6 cannot be treated as suppression, and the NCLT is bound to admit the application upon being satisfied of debt and default, unless defects exist. So rejection on grounds such as apprehended misuse or the NCLT's subjective assessment of applicant's code is impermissible. NCLAT was very clear that in case the application is complete with respect to the minimum requirements stated under Section 10, and also it proves that there is debt and there is default, then the application has to be admitted. In Antrix Diamond Exports Private Limited versus Bank of India, NCLAT dismissed the application on the ground that the application was an attempt to scuttle the SARFAESI proceedings and delay the recovery of assets by the creditors. NCLT had dismissed the application. NCLAT set aside the judgment while holding that SARFAESI proceedings were an extraneous factor and not required to be disclosed in the terms of the code or Form 6. So technically speaking, we have other judgments also where continuation of SARFAESI proceedings is, yes, understood widely as some kind of a malified intention to take the company to Section 10 application, but the code is very clear, Section 10 is very clear that if there is default and if there was debt and if there is default, Section 10 application can be filed by the corporate debtor.
Fraudulent or malicious intent. This has been held in many cases, which is also called abuse of the process. There is a special section, which is Section 65, subsection 1 of IBC. It says that if an application is found to be filed with fraudulent or malicious intent or for any purpose other than bona fide resolution, NCLT can dismiss it and even impose penalties ranging from 1 lakh to 1 crore. And in one case, I remember it actually imposed a penalty of 1 crore also. This provision applies equally to debtor-initiated cases. Courts have been vigilant to ensure that Section 10 is not misused as a shield against creditors or shield against investigations. In case Wave Megacity Center Private Limited versus Rakesh Taneja and others, the NCLAT held that a large real estate developer, NCLT dismissed the company petition under Section 10, holding that it was filed with fraudulent intent to escape liabilities after collecting 90% of dues from allottees or home buyers and that also numbered to 2,300 approximately, and project is stalled. The NCLT found the directors had resigned before filing this application to shield themselves from investigations and from, again, various actions from the creditors. This was held to be basically an abuse of the process. Even in this case, 1 crore penalty was imposed. And in fact, NCL 80 also on 5th January 2023 upheld this order of NCLT, saying that IBC cannot be used to legitimize fraud or avoid genuine claims. Similarly, in the case of Agroha Paper Industries Private Limited versus Bank of Maharashtra, on 25th of July 2024, NCL 80 noted debtors conduct dodging willful defaulter proceedings, attempting settlements while simultaneously filing Section 10 to halt a nearly complete asset auction, and concluded the filing was in bad faith, and this was rejected. Similarly, NCLT Mumbai, in the case of Diva Jewellery Private Limited, have dismissed Section 10 petitions where the timing and circumstances indicated an ulterior motive, such as directors trying to preempt a creditor's recovery or to invoke moratorium to stall litigation. NCL 80, in another case, NISA Infrastructure Limited versus State Bank of India, held on 23rd of December 2020, that intention of promoters is only to get admission and followed by imposition of moratorium to stall all other proceedings. IBC, being a special legislation, cannot be used as a tool to one's advantage and others' disadvantage. So various cases where you can find that this has actually been considered as fraudulent and misuse of the abuse. Now, misuse to evade specific liabilities. Misuse to evade specific liabilities. Under this context, NCLT actually has also rejected petitions. In one case, known as Imperial Banquet and Dining Private Limited, the corporate debtor filed Section 10 after a government entity that is DTTDC sought to recover unpaid concession fee and taxes. NCLT found that the debtor still had significant assets, and the assets were about 5 crores and the dues were also about 5 crores, and was using CIRP as a shield to avoid paying legally recoverable dues. The application was dismissed as a malicious attempt to misuse the insolvency process for a collateral purposes. Now, also coming to pending investigations or regulatory actions. The pendency of an inquiry by SFIO or Enforcement Directorate does not by itself bar a Section 10 filing, but it can cast doubt on the bona fides. Now, in the same case, like Wave Megacity Center Private Limited versus Rakesh Taneja, NCL 80 observed the company was facing criminal investigations and consumer lawsuits, while these by themselves have no bearing on Section 10 admission. This is a different company of Wave Megacity. The context supported the finding of malified intent to dodge those proceedings, and the courts will examine if the insolvency filing is intended to stymie investigations or enforcement, for example, by seeking moratorium on asset seizure, and if so, they may invoke Section 65. That is something which is important. So many applications, in fact, not smaller, many applications that actually has been held as malicious in intent.
Then we have, the idea that pendency of recovery proceedings are not sufficient by itself. So on the flip side, we have again some judgments, as we said, as I talked about Getz Cables, which is a very recent judgment, as recent as it's a 2025 judgment. And here again we see that the the thought process at NCLAT has changed a bit. As I said earlier, in Getz Cables Limited, NCLAT said that mere rejection of a Section 10 application because SARFAESI is pending is not fraudulent. So now I believe that there is a understanding that Section 10 rather should be read in its actual form, and the intent there of the government in the IBC is that as long as there is a debt and a default, a company should be allowed to apply for Section 10, complete the procedure, and the insolvency should be initiated for that company. And this idea that NCLT and NCLAT will use their powers under Section 65 and say whether this kind of a CRP is just or equitable or not is something that is changing now. So we have Getz Cables where NCLT clarified that mere existence of SARFAESI proceedings does not establish fraudulent intent. So now we have this example for those companies where Section 10 application has been filed and SARFAESI proceedings are going on. So the bank or the opposing creditors cannot say that this is to circumvent the SARFAESI proceedings. In Leo Duct Engineers, which is a 2017 judgment also, it was held that initiation of proceedings under SARFAESI Act cannot be a ground to reject an application under Section 10 of IBC if otherwise it is complete in terms of IBC and including Form 6 therein. So my personal view is that although there are various judgments which talk about how NCLT, adjudicating authority, can invoke Section 65 and stop a fraudulent application, if the application justifies debt and justifies default, then irrespective of ongoing criminal investigations, other difficulties, Section 10 should be a feasible proposition for a company.
NCLT has also held in one case that if a company is found to be profitable, it is having sufficient income, and still it files an application under Section 10, that is also liable to be rejected. As we've already discussed about this case in this video, that's Vyomith Shares and Stocks Private Limited, NCLT observed that a profit-making company seeking insolvency may be proceeding with ulterior intent and held that such an application can be rejected on that ground. The logic is that IBC is meant for insolvent entities. A healthy company cannot misuse it to wipe out some of the offenses that they have done.
So again, we have the IBC amendment coming in, which does talk about how the NCLT should only look at the default. The insolvency definition as per IBC is very clear that the definition is limited to the idea that even if the company has 1,000 crore rupees of assets and it is not able to pay creditors in time, insolvency is there. So it is not about how much assets one has and how much liability somebody has. The idea with respect to insolvency is that the company is not able to pay that debt within the set timeline. So there it needs some differentiation, although courts, NCLT and NCLAT have gone towards equity and tried to kind of stop insolvency for those companies where they find that the financial statements show a healthy picture.
So just one more judgment, I think not really very important, but yes, it is also says that while the application under Section 10 is pending before the adjudicating authority, in the meantime, the management changes the registered office of the company or changes the name of the company. just to avoid public visibility and just to kind of one arm of a group actually is just kind of cutting one arm and throwing it away. So that was also not allowed because the NCLT found that while this application is pending before NCLT, the board of directors decided to shift the register office of the company and also change the name so that the one company's name is not associated with the other group companies. So that was also not permitted. So see, like, then we only have to discuss one amendment which is there in the proposed amendment bill 2025. Now, the bill now proposes that in section 10 petitions, the corporate applicant is not required to give any option of name of the proposed IRP because it was thought that the IRP that they would be proposing would work in tandem with them, so they would actually be able to fulfill their objectives in connivance with that particular IRP. So that power has been taken away, and in case of any section 10 application, the IRP would be appointed by NCLT based on the panel of the IRPs with them. So to conclude, we can say that petition under section 10 is difficult. One, it needs a lot of information, updated financial statements, provisional financial statements, assets and liabilities, all mortgaged assets details, guarantees, shareholders list, members list, and all this is required as up to date as 14 days prior to the filing of the application. So many corporate applicants are not able to do that. Secondly, the authorization is also a very important part. There are a lot of reasons for actually getting it rejected because the creditors oppose such applications. Those creditors who have started action under section 13.2 and 13.4 of SARFAESI Act, and in that period, if the corporate applicant, corporate debtor goes for section 10 petition, so they oppose and they expose the intent of this application. So therefore, there are many rejections. So that is one reason that there are only 6% petitions under section 10, and that also is reducing. And out of this 522 applications so far till June 25, in fact, more than 25% applications were in the first 2 years before the insertion of section 29A, where all these applications were being filed to submit a restructuring proposition to the creditors. To conclude, this is the reason that section 10 applications are too less and it is actually getting rejected because of the perception of the creditors, opposition of the creditors, and finally adverse orders from the adjudicating authority. Thank you.